Welcome to the Pop Up Law series. The idea of increasing the retirement age for judges, which was fixed almost 70 years ago, has been mooted for decades as a solution for dealing with the mounting pendency of cases and judicial vacancies. The Union Minister of Law recently said that there is no proposal to increase the retirement age of the Supreme Court and High Court judges. It is not that the amendments have not been made concerning important subjects earlier, such as initially the voting age in India was 21 years, which was lowered to 18 years in the 61st Amendment of the Constitution of India, officially known as the Constitution 61st Amendment Act 1989, for the elections of Lok Sabha and legislative assemblies of the state. Similarly, marriageable age, as per the 1929 Act, where marriage of girls below the age of 14 and boys below the age of 18 was prohibited, this act was amendment in 1978 to increase the minimum age to 18 years for females and 21 years for male. The Prohibition of Child Marriage Act of 2006 replaced the 1929 Act with the same minimum age limit, which was 14 years increased to 18 years, and then on 21st December 2021, the Prohibition of Child Marriage Amendment Bill 2011 was introduced by the Union Minister of Women and Child Development, seeking to increase the marriageable age from 18 to 21 years. But why the retirement age of the judges has not been increased? The Constitution 114th Amendment Bill was introduced in 2010 to increase the retirement age of High Court judges to 65. However, it was not considered in Parliament and lapsed with the dissolution of the 15th Lok Sabha. According to Article 124, Subclause 2 of the Constitution, the age of retirement for Supreme Court judge is 65, and as per the Article 217, Subclause 1 of the Constitution, High Court judge retire at 62. Initially, the retirement age of High Court judges was 60, and which was later in 1963 increased to 62 through the 114th Constitutional Amendment. In Western democracies, the retirement age for judges is around 70 years. Some of them even opt for tenure for life. In the Supreme Court of United States and in constitutional courts in Austria and Greece, judges are appointed for life. In Belgium, Denmark, Ireland and Netherlands, Norway and Australia, the retirement age for judges is 70 years. Judges in Canada and Germany retire at 75 and 68 respectively. The judge population ratio in India is among the lowest in the world at 19.66 judges per million, that is 10 lakh people as of today. In 2016, the UK had 51 judges per million people, the US had 107, Australia had 41 and Canada had 75. According to National Judicial Data Grid data, more than 2.84 crore cases are pending in the subordinate courts, 43 lakh cases are pending before the high courts, and 57,987 cases are pending before the Supreme Court, and hence, it is necessary to increase the number of judges to deal with the enormous pendency of the cases. Increasing the retirement age of judges will have significant benefits. Senior serving judges will bring with them years of experience. It will ensure the continued presence of a strong talent pool of experienced judges. Along with the experienced judges, new judges can be appointed and will address the problem of mounting areas. And most importantly, it will render post-retirement assignments unattractive and strengthen the rule of law and the independence of judiciary to sustain democracy. Please let us know your views on this, and to know more, please click the link below.